I want to thank Nicole for putting this together. This panel actually began over lunch in the spring, in which well, you can leave it on there. We're going to be focusing on number 10. We're focusing on point 10. Began with a conversation in the spring, and the session asked whether neurointervention can restore competency. And Stephen is absolutely right. We don't talk, competency and sanity are thrown together in this context. So we'll talk about competency, although most of the people we're talking about are insane. And can they be restored? And if so, should they? It builds on the Panetti case, which Stephen talked about, in which the court reversed both state courts and federal district courts, in which the Supreme Court reversed them, all of whom found that Panetti, despite a history of insanity that his wife testified during trial, had gone back into the mid-'80s. He was found competent the second time. The first jury found him incompetent. They moved it. The second one found him competent. He had been on and off psychotropic medications for a very long time. And if you have the brochure, the language that is not italicized is almost exactly from the federal district court's findings that he was competent to be executed. There was testimony by a fourth expert, which raises somewhat more difficult issue. He suggests Panetti doesn't even understand that the state of Texas is a lawful constituted authority, but rather he believes the state is in league with forces of evil that have conspired against him. In fact, he was delusional. And he thought because they wouldn't permit him to preach the gospel, they were going to kill him. That didn't matter. It was irrelevant. Because Panetti knows he committed 2 murders, he knows he is to be executed, and he knows the reason the state has given for his execution, he is deemed competent to be executed. There's a follow-up on this. Last August, the Fifth Circuit found him competent again. In the full paper, of which my talk later will be extracted, there are 6 cases that still didn't get the message of Panetti. They're still finding that if you can effect a simple syllogism, you're competent and we're going to execute you. And for those of you who are interested, I can tell you what the cases are. So this is a real struggle. The other case, which Stephen also wonderfully synthesized for us, and is the Eighth Circuit Court of Appeals case in Singleton against Norris. This was the full Eighth Circuit, so I guess 11, 12, 13 judges, I'm not sure how many heard it on remand. There was no question Singleton had positive symptoms of schizophrenia. He was delusional, his behavior was grossly erratic. And it could be dampened somewhat by the involuntary use of psychotropic drugs to restore his sanity. One of the things that's interesting about that case is that he was found, I'm sorry, let me back up here. The argument was made that it was no longer medically appropriate once a death warrant was signed and once we knew what time he was going to be killed. It couldn't be medically appropriate for him to be given drugs to make him competent and then given drugs to kill him. And a majority of the full Eighth Circuit said that wasn't relevant, which was one of those things that kind of made my hair stand up. How could that not be relevant to whether it was in his medical interest to be coercively drugged? So there we are now. I will save my own remarks for later in the session, and limit it at this point to two points. One, I take on the question of whether under these circumstances, any prisoner who, again, following on Stephen's remarks, we have to assume was sane at the time, at the time of his trial, at the time of his sentencing, and became schizophrenic after 20 years on death row. So I want to question whether those people can ever have their competency restored. And I'm going to do it by kind of breaking down schizophrenia into its types, what we're talking about, positive symptoms, negative symptoms, cognitive symptoms, and suggest that while we can deal with the positive symptoms, it's not at all clear in this kind of population that we can deal with the negative symptoms and the cognitive symptoms. And I'm going to take a bit of a flyer on this because I'm going to base it on really my own personal experience dealing with two very dear friends who were diagnosed with schizophrenia late in life and were more or less drug resistant, and in a certain sense living in their own kind of death penalty isolation and suicidal. So with that, I'm going to pass it on to Francis and thank all of our panel for participating here. So go ahead.
Great. Well, thanks and good morning. I'll play the role that Katrina did yesterday. I'll say just a few words, and then after all of our panelists, I'll take the microphone out so we can have robust discussion, and we should have plenty of time for discussion. I just wanted to offer one bit of historical context, both for discussion here and maybe for the remainder of the conference. The challenges, of course, of new neurointerventions are many, and the questions that we're addressing are in some ways novel and new, but I'd suggest that it's useful to not be too ahistorical, and I want to give just 2 data points on that point. The first goes back to the 1930s and then the late 1940s, having to do with the Nobel Prize that Higas Moniz won, and many of you will know what that's for, the prefrontal lobotomy. And I want to give you just one quote from the Yale Law Journal, give you a sense of the reaction, at least some of the reaction initially to that. And this is an article called Toward Rehabilitation of Criminals. And of course, they weren't talking about this particular rehabilitation of competency, but they were generally thinking about the ways in which the more we learn about the brain might improve the way that we treat those in our justice system. And they said, quote, "Psychosurgery has startling implications for rehabilitation, and it is proving successful in an increasing number of cases. Perfection of so relatively simple and inexpensive a rehabilitative technique as the prefrontal lobotomy promises to be a major contribution to the cure of criminals." Of course, we know what happened there, but the question I want to raise for us is, by what criteria ought law policymakers look to science, take that risk-benefit ratio that science gives us, and say, okay, it's good enough for us to implement. For instance, in this context, even if science isn't ready yet to provide some of the rehabilitative techniques we want for competency, what if it got a little bit better? Is that enough for us? How would we determine that? And I want to jump ahead on that same theme to the 1970s now and give you one more passage. This now from Fortune magazine, describing another interdisciplinary conversation that was going on, and I would hope that you, as I, see some striking similarities to this description, again, 40 years ago. And here's the quote: "A broad interdisciplinary effort is getting underway to explore the biological nature and origins of violence. Biologists, biochemists, neurophysiologists, geneticists, and other natural scientists are probing with increasingly precise tools and techniques in a field where supposition and speculation have long prevailed. Their work is beginning to provide new clues to the complex ways in which the brain shapes violent behaviors. In time, these insights and discoveries could lead to practical action." And it goes on to discuss many ways in which that might happen. And this was a popular article at the time talking about the scientific work of those doing psychosurgery. It was a book called Violence in the Brain. 2 Harvard scholars, Frank Irvin and Vernon Mark, neurosurgeon and psychiatrist, who were part of a movement at that time to do something, again, similar to some of the things we were talking about yesterday, which is to better understand what it is in the brain that contributes to violent aggression, and they were looking at the amygdala amongst other things, and then to propose, well, what if we surgically removed or somehow otherwise lesioned that, ought we to be doing those things? And I want to give you one quote, one final quote about, well, what do we do with all of that? And there was a New York Times article at the time. I interviewed a number of people, and again, came back to this question of, do we know enough? And here's one quote that I always find provocative from one of the, not these 2, Mark and Irvin, but another physician who was doing this work in the criminal justice system, advocating for and doing psychosurgery. Quote, "We must work in partial ignorance to relieve suffering." So I return to this question of competency. Of course, we can propose the what-if question. What if science gives us the impossible to give, really, magic touch or magic pill? But they won't. But there's still a very wide space where science might tell us a heck of a lot more than it did just a few years ago. And yet that would still be, to use that phrase, partial ignorance. So how little ignorance is enough? What about that risk-benefit ratio? And again, by what criteria will we say we have this ability, say, to perhaps restore competence, but with this set of side effects? What do we do as law in this particular context, or in the many other contexts that we were talking about yesterday, or that we'll talk about today and tomorrow? What are our criteria? And I don't have a great answer for that, except to say that whatever our criteria are, we better be careful about them, because some of these previous criteria, such as, well, let's wait till a Nobel Prize is won, or, well, let's wait until work is done by top leading scholars at Harvard, those didn't seem to be enough. Or maybe we want to look historically and say that was the right thing to do, to try. I don't know if we want to say that. So that's just by way of general context. I hope we'll keep that in mind. And now we can turn to the more specific reactions to the Panetti case. And when we do this, we'll start with Judge Davis and then work down. And we've met Stephen and Chris and Nicole before. We haven't heard from you, Judge Davis. So if you wouldn't mind saying a little bit about who you are and your interest in this, and then your comments.
Thank you, Francis. I want to express my deep appreciation to Nicole and the consortium for the kind invitation to be here and to participate. It's really a great joy for me. As Francis and Stephen and Nicole know, I had the good fortune a couple of years ago to be invited to be one of 2 judge members of the MacArthur Network on Neuroscience in the Law, a really extraordinary group of people looking forward to see where the intersection of law and neuroscience will take us, and to do what they can through research projects, studies, and other endeavors to make sure that the place we go in the law is a place we really want to go for the betterment of our society. So it's a real joy for me to be here. I am a United States Court of Appeals judge on the 4th Circuit. I'm resident in Baltimore. I hear appeals from South Carolina, North Carolina, Virginia, and West Virginia, as well as Maryland. This year I'm 27 years on the bench, the first 22 of those on the state and federal trial bench. So I bring a judge's perspective to the work that you all are doing and to the work that the MacArthur Network is undertaking. So let me say a few words about Panetti, and I will take a decidedly judge's view of such things, because I don't know anything about the science, except what I'm able to absorb from being around all you brilliant researchers, psychiatrists, psychologists, and my good friend Steve Morse and Francis Shen. One of the things that strikes me about Panetti is how it's such an exemplar of how broken our criminal justice system is. And without going in too deep in the weeds, for some of you non-legal types, let me just briefly sort of give you a quick history. The great writ of habeas corpus, and next year, by the way, I'm really delighted. I'm going to be a presenter in London at the ABA meeting celebrating the 800th anniversary in 2015 of habeas corpus. And the habeas corpus notion of the law of the land is where Jefferson and Madison et al. Drew the notion of due process. So that's what we're talking about here. But the great writ embodied in our Constitution, of course, borrowed from England and the Anglo-Saxon traditions of the common law, had for nearly 200 years been a source of justice in federal courts, particularly for people convicted in state court who had plausible claims of denial of constitutional rights. And again, I'm not going to give you a long history, but some of our most notable Supreme Court decisions of the 20th century were decided under the jurisdictional head of habeas corpus. Probably the most prominent one is Gideon versus Wainwright, the 1963 decision by the Supreme Court in a case coming from Florida in which the court said, yes, every person in the United States justice system, state and federal, is entitled to a lawyer. And if he or she cannot afford a lawyer, then one is appointed, as Stephen suggested, sometimes of questionable competence or quality, but one is appointed to represent the defendant. And so my point is that there's this tremendous history and background of federal courts sort of looking over the shoulders of state courts in ways that, in my view, historically have really increased the quality, the quantity, the profundity of justice in our system in ways that just can't be overstated. And what began to happen during the tough on crime days of the 70s and the war on drugs and thereafter, first the Supreme Court and then Congress got on the bandwagon to severely restrict to the point of diminishing zero to zero the ability of federal courts to, as I put it, look over the shoulders of state courts to ensure that substantial justice is achieved in a vast majority of cases. That's a 30-second history of about 200 years of developments, procedural developments. And the reason this is important, among others, is frankly, and I used to be a state court judge, and indeed, I was an elected state court judge for a brief period of my time, although that's the worst possible way to select judges. And bless her heart, Justice O'Connor has made it her mission, having retired from the court. She's been all over the country for the last 7 years, beating the drum of let's get rid of elected judges. But I'm in Georgia, I get that. But the point is, if you have any doubt about the political impact on judicial decision-making, I refer you, I forget the name of the case, but Justice Sotomayor wrote this extraordinary opinion last spring. And the opinion is called a dissent, or maybe it was a statement on the denial of certiorari. So this was an instance in which the Supreme Court refused to hear a case. This particular case happened to be a death sentence case from Alabama. And the Supreme Court declined to hear the case, and Justice Sotomayor, who believed the case should have been heard, wrote a dissent from that decision not to decide. Doesn't happen very often, very rarely actually. And she makes the very powerful point about this one county in Alabama and how judges in that county or that area of the state had routinely rejected jury recommendations in capital cases for a life sentence and had instead imposed death sentences. And she not so obscurely made it clear that this was in some important way a function of elected judges. When judges have to respond, particularly as they do in Alabama and some states, in partisan, I mean, you run as a Republican judge or as a Democrat judge in some states. And when judges have to respond in that way to the electorate, and they're up every 4 years or every 6 years, unlike some judges, such as here in Georgia, the appellate judges don't have opposition, they simply run yes or no candidates. But anyway, Justice Sotomayor made the point of how important it is that federal courts continue to scrutinize judgments, particularly judgments coming out of capital cases. My point in sharing all of that with you is simply by way of background that what you see in Panetti, which was decided in 2009, I guess it was, or yeah, 2007, What you see in play in the 5-4 debate between the two sides, among other things, is Justice Thomas's dissent, and he starts it by saying, quote, "This is a simple case." And part of the reason Justice Thomas and the dissenters believe it's a simple case is because of something called the Anti-Terrorism and Effective Death Penalty Statute, which was Congress's, I referred earlier on to Congress's jumping on the bandwagon. Congress in 1996, during the administration of President Clinton, and President Clinton signed this act, severely restricting the ability of federal courts to, as I said before, look over the shoulder of state judges. And the reason I bring it up in the context of this particular discussion, and I'm almost finished, is because what's happening in so many scientific areas, such as neuroscience and genetics and in others, what's happening is that as we hopefully come to a near close of this period of mass incarceration and extraordinary use of the death penalty across America, what we're going to see in courts in the next decades are legitimate claims of procedural unfairness, of denials of fundamental justice, and some of those claims are going to be informed by newly evolving scientific standards. And what I'm afraid of is what I'm distressed about in Justice Thomas's opinion in Panetti. And he says, in part, we can't even hear this case. Federal courts can't even look over the shoulder of state judges anymore to vindicate legitimate constitutional rights. That, ladies and gentlemen, is a very, very scary, distressing prospect. And so I'll conclude there. I'll have plenty more to say on this panel and a later panel, but we've started down a very dangerous path in terms of procedural justice, where today, for a federal court to grant relief later on, the federal court must conclude not that the state court system got it wrong, but that the state court system the judges acted unreasonably so in getting it wrong. Let that rest in your brain for a moment. A federal judge, a federal court, has to be willing to say, and frankly, some significant number have been willing to say that in the 18 years of the statute, particularly in the Fifth Circuit, I should say, the Supreme Court, that is, that the state court judges reviewing these claims acted unreasonably, which is sort of another way of saying they were stupid. We shouldn't have a legal regime that for even the worst of the worst, someone who's committed a heinous crime, it's inconsistent with our notion of human dignity that Stephen talked so much about this morning. I submit to you it's inconsistent with our notion of human dignity that we have to call judges stupid before we can vindicate plausible, often compelling claims of constitutional deprivation. And what we have in Panetti, on the other side, of course, is our dignity justice, Justice Kennedy, who time and time again has held the line true in these 5-4 decisions. And I just posit, what on earth would the world look like? What would the United States look like in criminal justice and in other areas if we didn't have a dignity justice? I'll yield back the balance of my time, and I'll take off my future time, the excessive time I've spent in my opening comments. But thank you all very much for allowing me to be here and to participate.
I second everything Andre had to say about the broken criminal justice system. On the other side, and I'm not, because I'm on Andre's side on this entirely, on the other side, what had happened in light of prior Supreme Court decisions that led Congress to pass the Anti-Terrorism Effective Death Penalty Act was that appeals had become so slow and so cumbersome that the idea was justice delayed is justice denied. And this was an attempt to cut through that. Well, okay, we can all understand that. But at the same time, we don't want it to be the case that we make the bar so high for overturning the state court decision that justice is completely denied. And I think that's what we are looking at. And in fact, if you look at the Panetti case, the bulk of the discussion was not about the substantive issue of whether or not Panetti was competent or not. The bulk of the discussion was about whether the AEDPA applied in this case or not. And by the way, as you can imagine, it is incredibly technical stuff. I only want, I've had my innings on this, so I just want to make 2 points, one of which I made in my talk and the other of which I did not. And it goes to the standards raised by Chris in his very good question of how broadly or how narrowly we should understand rationality. If you look at the competence instruments that have been developed for things like competence to stand trial, the MacArthur instrument is the most well-known, or the MacArthur competence to consent to treatment, basically it started off by looking at the precedents, and there were 4 levels of what competence might mean. The lowest level was, can the person say yes or no? Well, that's effective. Pretty much anyone can do that. So that wasn't really interesting. The next was what has been termed understanding. Can you parrot back the information you've been given? The third is, do you understand the relevance of that information to you? That's called appreciation. And allegedly, the highest level is your ability rationally to manipulate that information, understanding that it applies to you. That still leaves open the following question. So, in Panetti, he understood, as I said, narrowly speaking, that Texas had convicted him of murder and that was why they were going to put him to death. But his material, rational understanding of why it was being done was this delusional system about being persecuted and the willingness to prevent him from teaching. An analogy, Andrea Yates, the Texas mom who killed her 5 kids, she drowned them. The story briefly was she believed that she was corrupting them, and that if she corrupted them any further, they would be condemned when they finally died to being tormented in hell for all eternity, which is a very long time. So she decided better to kill them now while they are still innocent and would go to the Lord. Did she understand that she was killing her children? Absolutely. Did she understand that it was against the law of Texas to do that? Absolutely. Did she understand that her neighbors would disapprove? Absolutely. Did she understand what she was doing in a broader sense? Absolutely not. Her material motivation, her reason for action was this delusional system, we think. And by the way, both sides agreed she was frankly delusional, whether she was delusional. Now, should we go narrow or should we go broad? Now, as you know from what I've said, I go for the broad interpretation here when a lot is at stake. But again, that's not a scientific matter. It's a normative matter. Here's my every other Tuesday case, and then I'll make my last point. What do we do? Now, think about Andrea Yates for a moment. If the facts were as she believed them to be, she's at least plausibly got a justification, a good moral justification for killing her kids. Better they be killed now and not be tormented in hell for all eternity than to live out their natural lives. One could imagine, okay, do the moral weighing, and you'd say, well, better to die now. Okay, how about somebody who delusionally believes their spouse is unfaithful? And no matter what argument or what evidence they hear to the contrary, they are sure their spouse is unfaithful. And everyone's trying to convince them, no, it's not true, but they do not believe it. They weave all the counter evidence into their paranoid tale. So they kill their spouse. Now, they would not be justified in doing so. Their material motivation is clearly irrational, guilty or not guilty. That's what I call my alternative Tuesday case. Some Tuesdays I want to acquit that person. Some Tuesdays I want to convict that person. And despite the fact I've been working in this field longer than I care to admit, I haven't come to yet a rational conclusion. My last point, and this was raised by something Andre said as well, and now I'm limiting myself to the death penalty. As we see, and Nita Farahani, who you'll be hearing from later today, knows more about this probably than anybody, as we will see more and more increases in our scientific understanding of human behavior, what the Supreme Court has held in death penalty cases is, over and over again, essentially you can throw the kitchen sink at mitigation. Even if there is no statutory mitigating factor that the state has provided for, the judge must let in almost anything that could go to mitigation. Okay, we've got to be really open-minded about mitigation. Now, excuse me for using a swear word. We want to be open-minded, but not so open-minded that our brains fall out. And so there's got to be a limit on what will be considered really relevant to mitigation. And so I think the task for advocates on both sides and for appellate courts, when they're faced with claims of you should have or should not have admitted this particular bit of evidence that the capital defendant at capital punishment proceedings wanted to introduce for mitigation purposes, is it what I call really relevant because it provides evidence of a mitigating condition, or is it rhetorically relevant? My favorite trope for this is the old hole in the head. See, he's got a lesion. We can show that on a scan. Well, what's the mitigating condition? Has that lesion diminished his rationality? Has that lesion diminished his self-control? What's the mitigating condition? If it hasn't, then it's only rhetorically relevant. And sort of adjudicating that, assuming the death penalty remains constitutional, I think is the real task for the future of law and science at death penalty proceedings.
Hello. Look, let me say first of all that I was very pleased to be invited on this panel because you just don't get this opportunity in Australia. I was never going to be on the fitness for execution panel in Australia because that's not the sort of thing we do. And as a consequence, this 5-minute spot actually took up more thinking time than the whole paper that I gave yesterday because I hadn't thought about it before and I thought it was just very interesting. And there was a big problem with it, and the big problem was that every time I thought about the question, which was in what circumstances might it be ethical to medicate someone so that they're fit to be executed, no matter which avenue I ventured down, I always ended up at the same place, which was just don't execute people. But that's useless. That's no good. You know, that's almost everyone, apparently, agrees with that. And anyway, it wasn't what we were asked to do. We were asked to assume that execution was okay. So, and also, I'll be upfront about this right from the start. I didn't want to come up with a position where I would say don't execute people, because then I was worried that that was just me, a sort of moral leakage from my anti-execution thing. So what I was really looking for, I'll say this right from the start, didn't necessarily have to be right, but I had to be able to defend that you should go ahead and execute. You should go ahead and medicate the person, as abhorrent as execution is. So anyway, that's how I took the task. All right, so the first attempt was, okay, let's treat restoration as capacity as a therapy. I thought that's a good way of doing it. And viewing it this way, you certainly could give some people, I think, antipsychotics to restore their competency to be executed, but only if they themselves were competent to accept the antipsychotics knowing that this would mean that they were going to be executed. And of course, these are people that are already not competent to be executed. So there's not going to be much room there. I mean, it's possible, there are two different criteria. It's possible that there could be somebody who could be competent to receive the drugs that is going to make them competent to be executed, but yet not competent to be executed. They're going to have to understand all of that, but not understand. So they understand they're going to be executed, but they don't understand the reason for being executed, but they're still going to say, yeah, fine, give me the drugs. There's not going to be many of those people, so I don't know really how relevant that is. And similarly, for people that are incompetent to accept the therapy, there might be some people for who you could do that because they might have given an advance directive along the lines of, should I become incompetent to consent to the therapy to restore my competence to, the whole thing. But there's not going to be many people that are going to do that advance directive either, I assume. I don't know. I mean, death row is great, so perhaps there will be some. But anyway, in the end I thought, forget therapy, that's not working. What about if we say that restoration is part of the punishment? Because frankly, that looks more like what we're doing anyway. So we decided to kill the person, and so we need to restore. We can't kill them, the Supreme Court said, until we restore their capacity. So this, giving them antipsychotic, is like a sort of appetizer to the entree that is the lethal injection. So they're both punishment meal, right? It's just that it's in two parts. And that would be good, because then you wouldn't have to worry about the person's capacity to accept the treatment, because we don't care about that with punishment. So that's all sorted. The downside of this, though, is that we're only talking about this dilemma because the Supreme Court has said you've got to be competent to be executed. And now the treatment to make you competent looks like part of the execution, so it looks like the way that you're trying to get around this rule is by violating the rule, and that didn't seem right, so we got rid of that. In fact, I was completely stuck until Thursday night. Paul Davis and I, we've been out to dinner, we've had a few drinks, and which, is the way to solve these things. That was my mistake. I'd done all of this thinking completely sober. And we wondered whether you could see this not as a treatment, or whether there was a third way. So this is the third way. This is what we came up with. When you think of people in the grip of mental illness, you think of people in the grip of mental illness. They're not themselves, but this isn't because they're somebody else. They are in some way temporarily overwhelmed by the mental illness. They're still in there, we say to ourselves, but they're temporarily inaccessible because of a carapace of psychosis. Do you like that? I quite like that. I was quite proud of that bit. I think that was my contribution to this, actually. Carapace of psychosis. All right, so what if, when you're returning someone's capacity, all we're doing is retrieving them from somewhere that they're temporarily and possibly inadvertently inaccessible. We can't execute them while they're in that place, so we need to bring them back. What if restoring someone's capacity under this view is no more a treatment or a punishment than simply escorting the person back inside the prison walls if they'd even inadvertently stumbled to freedom? Now, Paul and I aren't sure that any of this is right. I sort of hope it isn't right, because I really hate the death penalty thing. But anyway, it did look to me that, it looked to us, we stopped reviewing it after that, what if it was right, that it might be a way of ethically restoring someone's to execution competency, regardless of how unethical actually killing somebody is.
Okay, so in preparing for this comment, The question that I asked myself was, can competency for execution be restored? And there were various, what I thought were really unhelpful answers. So some people point out things like, look, whoever is treated, we're not actually curing them. There's still there are still these symptoms, we're merely calming them, and the person still remains insane beneath this mask that we've imposed on them. Another thing that I found rather unhelpful was others who say, look, it's only temporary, right? And because this is only a temporary solution, therefore it's not a proper treatment to inflict on someone. Why do I think that's a really bad point to raise? Well, because guess what? It doesn't matter that it's temporary, right? Because we're going to kill them afterwards. So hey, it's temporariness. That's right. Then you get references to things like synthetic sanity or chemical competence, which I think is meant to be a veiled way of saying, look, all that you're doing there is you're placing this not the real person, and you're going to end up executing some other individual. So perhaps this is an attempt to draw on our intuitions about personal identity and whether a person who's been treated with certain medications is no longer the right person, such that, look, yeah, sure, you've restored the competence, but now you've got another person there, so you can't execute them anymore. And I guess I find that unconvincing for the same reason that I find, well, simply for the reason that there are lots of people who do actually take various antipsychotic medications, and they seem to work rather well, and we don't suddenly say, oh, look, you're no longer the same person, I'm sorry, bring the insane person back, come on. So I found a lot of points in the literature which were rather unhelpful. That's just a taste of some of them. So back to the question, can competency for execution be restored? I think it's also helpful to think in this context of the sort of question that Chris Ryan started with. Well, what if it were the restoration of competence to simply remain in prison? And there was a fantastic paper that I set for my students this spring when I taught neurolaw, written by Anna Duffner, which talked about what happens to prisoners who as they age. So guess what? As humans age, some of us develop dementia, and we start forgetting what it was that we may have done. Is it fine to keep people in prison once they've forgotten what it is that they're being punished for? Now, Duffner doesn't actually get into the question of interventions, but I did find it to be a rather interesting question to consider. Well, what if we're thinking about the restoration of a person's ability to remember what it was that they did? Because although you may still feel that, look, we oughtn't keep a person in prison once they can no longer remember what it is they've done. They're saying, huh? Who am I? And what are these people? Why are they keeping me inside? Well, if you think that there are problems with keeping a person in prison there, would you still have problems with retaining them in prison, having them remain in prison, after you've provided them with medications which help them to remember what it is that they've done after all? So there have been various techniques that have been studied. I believe treatments for deep brain stimulation as a treatment for Parkinson's sometimes restores certain memories. So to the extent that memory is something that can be restored, well, maybe it would be possible to restore a person's competency to remain in prison, even after they initially develop dementia. So here you would be giving a person a treatment, not in order to make them well, simply for the sake of making them well, for the medical benefit, but rather to make it possible for them to be imprisoned for the purpose of retribution, because presumably retribution requires that they understand that what's happening right now to them is that they're being punished for a crime that they did commit. And they can remember that crime, and they can then sort of reflect like, wow, I guess I'd done it to myself. Right, so I do think that it's helpful to think of treating people, of the question of whether or not it's possible and whether we ought to restore competency for execution, to think of this alongside another question, the question of whether it's possible to restore competence for simply remaining in prison. So that's one point that I wanted to add to the discussion. But really, there are three other points I want to add, and I hope that I'm not going to go terribly over time. But I would like to split this up into three questions. One, there's the question of precisely what competencies are required, which is what Stephen got us to think about. And Stephen's answer was, well, look, really it's the lawyer that's in the best position to understand what competencies are required when we are talking about competency to stand trial. And so I thought, well, to some extent it is also a legal question, a social question, a moral question. What competencies might be required in order for a person to be competent to be punished, to be executed in particular. Why say that? Well, partly because of what I said yesterday as I introduced, with my introductory comments to this conference. That if what we think we want is retribution, well, there will be, there are different ways of understanding what's required for retribution. Is it just that you simply lose your life? Is that all that's required, that you die? Because if that's all that's required, that you die, well, then you're not going to require any particular competence. However, apparently, people might say, look, it's important that you understand what's about to happen to you. You are about to die. And why you are about to die? Because a court found you to be guilty of this particular crime, and then you were sentenced to this particular punishment, and now the punishment is about to be implemented. Now, to the extent that we think that the purpose of punishment is retribution, and we endorse this particular understanding of what is required for retribution to take place, then those are going to be the kinds of competencies that are going to be required. However, note that I personally am a pluralist about the aims of the criminal justice system. So it's not just that I think we want retribution, we may also want to have some level of deterrence. But not only deterrence, so I'm not going to grab some some innocent person off the street and punish them to get lots of deterrence. So deterrence isn't the only thing that matters. Incapacitation also matters. So we also want to protect society from certain kinds of individuals. Another aim might be rehabilitation, although people seem to have forgotten about the same, and maybe justly, given that prisons aren't the best places to rehabilitate people. If you put criminals with more criminals for many years, can you expect to rehabilitate them? Maybe not. However, the simple point that I'm trying to make here is that depending on what aim we take execution in this particular case to serve, whether it's, well, I don't think it'll serve the aim of rehabilitation, but it might serve the aim of incapacitation, of deterrence, or of others, or of retribution, then we're going to, I think we should be expecting different kinds of mental capacities, different competencies. And thus, that then brings me to the question of this is the second question, does a particular individual have the competencies that are required? Now, while I do think that it's a legal question, a social question, a moral question, what sorts of competencies might be required, I do think that it's going to be a sort of medical question, whether a particular person does actually have those competencies. So who is qualified to run the diagnostics on a particular individual to figure out whether or not they're just putting it on, that they're this incompetent, or whether they actually have those competencies? I would presume that maybe judges aren't in the best position, or maybe lawyers aren't in the best position, but actually practitioners, specially trained practitioners, who know how to administer the right kinds of tests, the sort of tests that are fairly foolproof, hopefully, such that somebody who's a very good actor won't be able to fool us into thinking that they're not competent. The third question is, I think, much more a medical question and a scientific question, namely, which interventions actually work, right? And again, and for whom? Because different people respond differently to different medications. So I don't particularly have much to say about that because I'm not a scientist, but I do know that well, as Stephen said, well, it's not like we've been inventing a great number of new medications which are very good at restoring various competencies. But why do I say that it's important to split this question, the question of can competence for execution be restored, into three questions? Well, because we do first of all need to figure out what exactly is it that we want to do when we restore somebody's competence. So do we want them to say, oh wow, guess what, I'm being punished for a crime that I did commit. Is it just that we want to wipe them out of the face of this planet? To put it crudely. Is it that we want to deter others? Because depending on what we say in response to this question, then we're going to arrive at very different answers to the question of competency, of what competencies we should be looking for. Then we'll need to ask the diagnosticians to look, to check whether this person has those particular competencies, and then to go to the medical person to say, right, given that those are the competencies that I now want restored, which are the particular medications that I should be giving to this particular individual? Because, given what I want to do to them and given what my aims are. So that's sort of how I would approach this question, rather than by, pointing to the fact that people aren't actually cured, or that the cure might only be temporary, or that it's a mask of sanity or a synthetic sanity. I think those aren't the right issues to bring up. Or for that matter that, hey, this is a misuse of medicines or a misuse of medical interventions. These are the, I think, real conceptual and important social legal questions.
Thank you.
Before we open up...
And no, I don't endorse capital punishment. Just to add.
I just wanted to point out an irony that came out of Judge Davis's talk, and that only a really broken system could illustrate. It is absolutely true that going back to a Supreme Court decision, I think in the 80s, Teague against Lane, 84, 85, something like that, the courts before Congress have made it very, very difficult to get habeas corpus and relief. Nonetheless, a California district court just this summer struck down the California capital punishment law because the average wait was 25 years. Right. So you've been there forever, but you don't have any procedure. Right. It is the craziest thing you'd ever want to see. And no wonder people go crazy. Justice Frankfurter pointed this out in an opinion in 1950. People on death row go crazy. They're there forever. So this is the irony of this incredibly broken system, is that they're in prison forever, but they don't get process.
Okay, we'll open things up. We'll start with Walter Winstead.
So I can yell while you're walking. I don't have any problem with projecting, I don't think. My question is really for Nicole, but I'd like to see what the other panelists think as well, because I totally agree with your point that you need to look at the purposes of punishment to determine which competencies are relevant. But then what I didn't hear at the end was what it seemed like a lot of what you were saying was pointing and going, well, why, under any purpose of punishment, do we care whether the person understands why they're being executed? It doesn't seem to matter from the viewpoint of deterrence. It doesn't matter for incapacitation. Execution isn't doing moral education or rehabilitation anyway, and retribution is supposed to be focusing on their mental state at the time of the crime, not currently. So I don't see, if we take your approach, why don't we reach the conclusion there's nothing wrong with executing them while they're incompetent? Contrary to what the law says, sure, but as an ethical question, what is wrong with executing the person while they're incompetent?
Okay, so in regards to retribution, I'll simply speak to this part. Here's my understanding of what's required for retribution. And that's an understanding that's informed by what Stephen said, that, look, it's important that a person understands what's about to be done to them and why this is being done to them. I would have assumed that part of the reason why we require this is because we want a person not to just feel like, what's happening to me? Here I am, somebody's sticking needles in me, they're doing something really scary, such that a person might feel panicked, they mightn't know what's going on, they simply feel like they're being mistreated. Well, here's the idea behind retribution. A, it's meant to be impersonal. It's not that, it's not conceived of as vengeance, right? It's that you brought something upon yourself and now justice must take place. Well, justice wouldn't take place if this person doesn't even understand what's going on. Okay, very, very good question. Why it doesn't take place? What's that?
I don't think we have an answer. I don't think we have an answer to that question.
But here's the reason why I think
Judges do.
Here's the reason why I think this is an interesting question. The reason why it's an interesting question, and especially in this particular context, right, when we ask the question of, hey, can competence for execution be restored, is because it gets us to answer the question, well, why not? You know, so to address the question, well, yeah, why not just kill the incompetent? If what we're after is retribution, wouldn't that be sufficient? And in having to answer this question, we're forced to have to be a lot more specific about what precisely it is that's required for retribution, qua retribution, rather than qua something else, like, you know, qua deterrence or qua reform, qua incapacitation. Well, again, there won't be any reform if you're killing somebody. They'll be very reformed. But perhaps I should just...
Go ahead, Steve.
I actually think the closest one could come, Walter, and you're absolutely right, at criminal conviction, that's the point of retribution. But one could have a view of retribution that would be very much in line with what Paul and Chris said about carapace and what you and Ken Levy have said in your chapter about the real self-view. You're not actually giving people what they deserve unless they actually understand what's happening to them. Now, if someone is not understanding, they're not getting what they deserve. You're giving it to the wrong, in a sense, the wrong person. Obviously, it is the same person, but not the person who you actually convicted. That was part of the reason I also, because there are problems with that view, I was attracted very much to Richard Bonney's dignitarian concerns, because those also underlie the competence to stand trial as well, where it's also hard to figure out on many grounds why we have this.
Walter, I think you're absolutely right. Very quickly, I agree always with about 98% of what Stephen always says. And
it's the other 2% that scares me.
No, it's as true today, all day, as it ever has been. Number one, Stephen is wrong. The death penalty is unconstitutional.
Oh, no, I think it is too.
Well, you've said 3 times today, it's as long as it's constitutional.
No, that's just for purposes of argument.
Okay. It is clearly unconstitutional. We don't have a court yet with the courage to say that.
Here.
All right? Number 2, I wish I had the money to commission a poll of the American people, state by state, jurisdiction by jurisdiction. My prediction is that you would find significantly larger percentages of people, well over a majority, a simple majority, who would say it's irrelevant to the justice, the legality, the propriety of the death penalty, whether there's competence. And you're absolutely right. I guess I disagree with Nicole to this extent, and others. There is indeed a revenge component of retribution. And a lot of people would tell you that it's a very significant component of retribution. I have little doubt that the American people, if they were asked, would say, absolutely, makes no difference whatsoever. So in that sense, and I use this as a term of endearment, our concern here, quite legitimate in my opinion, it's an elitist concern. And again, I use that term as a term of endearment. It's Justice Kennedy's, I said earlier, he's our dignity justice. And we've had dignity justices throughout our history, thank goodness. Question is, of course, are we going to have them in the future? And who are they going to be? But just reflect for a moment. Why don't we have the death penalty for rape now and for some other crimes? Because some dignity justices couldn't go all the way and say what Stephen and I now agree, it is unconstitutional. So they leave it out there. And, you know, there's criticism of judicial activism. What could be more activist than to say no death for rape, but death for murder? Where's that moral calculus come from? It's absurd. It's indefensible. And yet that's the scheme that we labor under. So it's a question of, and again, I use the term elitist, and I probably shouldn't, but it's an appeal to our better angels, and it's the best we got for the time being. Sorry for going on so long.
Just Coker against Georgia, the case that held, this is an interesting side note, the case that held that it's unconstitutional to execute for rape was written by Justice Rehnquist.
Okay, actually, I just wanted to make one further comment. May I? Okay, thank you. Yay!
Your show.
Yes! Must be some advantage, right?
You're the boss.
Yes, for once. All right, so maybe it's that I've got these really deep retributive sentiments. But it seems to me that if I do a good job, I deserve some pay. The question is whether I deserve, well, or so it seems to me. I'm not going to defend this too much. And along the same lines, it seems that people might deserve something bad when they've done something bad. Question is, what is it that they deserve? And I'm pretty sure they don't deserve to die. But that's a disagreement at the level of precisely which punishments is it legit to inflict on people, what modes of punishment we may use. So here are some different modes, right? Whipping, incarceration, the death penalty, fines, or shaming people. So there's different ways of treating people, some of which might be the wrong modes of punishment. However, on the assumption that it's not a complete slam dunk, that capital punishment is not something that's unjust in the sense of that on the assumption that somebody might deserve to die for some crime that they committed, then the question that comes up is, well, what is it that we're trying to achieve there? Is it that we're trying to get them to experience a certain kind of suffering, a certain kind of terror, a certain kind of regret that if only I hadn't done this, I wouldn't now be losing my life because guess what? I did this and I knew that what I was doing was wrong. And of course, all this stuff has to be sitting in the background, right? In order for us to come up with a decision that, right, this person that's now being sentenced is being sentenced to the most harsh kind of punishment. You've already got to assume that they at least knew that what they were doing was wrong, that they knew what they were doing, and perhaps that they could guide their actions in light of the judgments or something of the sort. But, so I do think that, without pushing the point of let's execute people, I do think that at least some of us might want to appeal to the notion that people should get their just deserts. And the real question is precisely what is it that justice requires, and whether justice requires a certain kind of conscious appreciation, for instance, like suffering. Now, some people think that that's so. But I do tend to agree with you that it does seem kind of barbaric, right? And kind of vengeful rather than just retributive. So maybe in having this discussion, what we're pointing to is the fact that maybe there's something very uncomfortable about the very notion of retribution. Sorry.
So, over here, Paul Wolpe from Emory. So when I do an exercise, when I teach this in my neuroethics classes, I do an exercise, I split the class into 4, and I have each one running a prison entirely for punishment, entirely for deterrence, entirely for rehabilitation, and entirely for protection. And then I ask them many questions, but one of which is exactly this one: should we medicate someone to execute them? And of course the rehabilitation prison is exempted because you can't, the purpose of execution is not rehabilitation, but the other 3 count. The punishment one, the questions come up just as you said them, Nicole, and that is, what is the purpose of punishment? But what I wanted to make a comment on was the other 2. And what I find students finding in both the other 2, where competence would not be necessary for deterrence, and competence would not be necessary for protection of the public from this person. We don't care if he's competent to protect the public, and we don't care if he's competent to send a message of deterrence to the public. They all want the person to be competent at execution. And the reason is a fundamental human belief that it is ethically unacceptable to kill someone who has absolutely no reason why under these circumstances. So it's an extra legal reason. And I think trying to find the reason within a legal context misunderstands the sort of meta question if you polled that public that you wanted to poll, I think most of them would find something viscerally objectionable, and then when you try to articulate it ethically, whether they could articulate it or not, I mean, sometimes that's a province of ethicists to articulate the visceral discomfort, but that most people find it somehow objectionable to execute someone who doesn't know why they're executed, and has nothing to do with the purpose of law, nothing to do with the purpose of punishment. It simply violates our sense of human dignity in some sense. And yeah, so that's what my students almost always come to in those cases.
Well, which of course puts the question, where does Justice Kennedy get off importing it into the Constitution of the United States? I think you're absolutely right, Paul. It's extra legal, it's a moral construct, and yet there are those who say we shouldn't import moral constructs into our Constitution, particularly into the Eighth Amendment, and yet we do it all the time, and yet, again, not to put too fine a point on it, we don't have the moral courage to go all the way and say, okay, let's rid ourselves of this dirty business.
Can I respond to Paul here? One of the best things I've read, most insightful things I've read on this notion that students are kind of at arms if you're going to kill someone that does not know the reason why he or she is being killed, was from Wittgenstein, and he gave a series of lectures on religion, psychology, and punishment, and he described it as an aesthetic. You know, I remember after the execution of Timothy McVeigh, a number of the parents who had lost children and family in Oklahoma City could say then, now I have closure. And well, what does that mean, closure? And I've never been clear about what closure means, because dead is dead. But they seem to think that unless they could put a frame around this, that something was wrong, and that frame Wittgenstein identified as an aesthetic, a personal aesthetic, and that sort of made sense to me. In fact, I've written about it, but it helps to me at any rate.
I would just point out the tension between Andre's poll and Paul's poll. Paul is teaching Emory students; those are elites. I actually think if we took the entire national poll, Andre would win.
Okay. My one contribution is actually, so in another thing that I read in doing research on competence for execution, just looking at all the different kinds of reasons that are stated for why it is that somebody needs to be competent for execution, I just remembered the suggestion was because the person that's about to be executed needs to be able to make peace with their maker. And I look.
That's in Ford.
Right. Now, I mean, being a materialist, I sort of found it interesting that what we would do is we would treat the person's brain to make the mind competent. I mean, presumably, if you're going to think that they're going to go to God eventually, then the mind is it's left untouched. They can already make peace with the maker. It's only the brain that's incompetent or something of the sort. But I do find it kind of interesting that
what about an atheist?
That people would cite
Nicole?
this. Sorry.
I'm sorry. What about an atheist? Should an atheist be made competent?
Should an atheist be made competent?
Yeah.
But that's what it is.
Make peace with their life.
I'm sorry. Go ahead.
That's it. The simple point that I'm trying to make, right, is that there is this idea that you need to reconcile something just before you die. Whether it's reconciling why the hell you're about to be killed, like here's this person that you're confronted with them, or you're about to go to God and say, oh look, I need to make peace with my maker. So again, you need certain competencies. An atheist probably wouldn't, I guess.
We'll go here and see what's there.
Hi, I'm Brandon Besh. I'm from the University of South Carolina. I study philosophy there. And I kind of have a typical sort of philosophy sort of question. I found this whole discussion a little bit curious because it seems to me that competence is a sort of agency word. And so there's a sort of category mistake in saying that you're competent to be executed because execution is done unto you. You're competent insofar as you have a pulse, right? And you can be killed. And so my question is kind of twofold. One, perhaps I'm just misunderstanding something and there's a different notion of legal competence to be defined here. And if so, what's kind of the difference between that and competence regularly understood as an ability to do something? And then two, perhaps what we need to do instead is just ask a different question and say, what are the conditions under which we think it's good for a society to execute? In which case we'd say, look, execution just isn't something good to do, but perhaps we work with the assumption and then we answer those questions.
My answer would be that I think your definition of competence as active agency is too narrow. That would be my answer, that there can also be competencies to have things done to you. And because, for instance, we do not allow medical treatment to be given to you unless you are understanding what's going to happen. Now, you could say, well, that means you're competent to consent and that's more active. And, we could argue about that, but that would be my sort of superficial answer to your question.
So, Nicole, as you know, I'm not a fan of retributivism, but I'm going to put on my retributivist hat in an effort to try to tease apart what you just suggested, this terror line that you ran. Right, so let's distinguish someone who is so incompetent they don't know that they're going to be executed, and someone who is incompetent in the way that Panetti was, where he knows he's going to be executed, he just doesn't understand the reason, or he doesn't understand in the broad, in Morse's broad sense, why he's being executed. Now, in the second case, all the more terror will be generated in the person who's going to be executed, but doesn't know why he's going to be executed, right?
Good.
So I mean, I want to say at least the retributive, and this is back to the judge's poll. If we ran the poll and I make it clear that the person did it and he was guilty at the time and he had the competency at the time, and you poll the folk retributivists everywhere, which I'd be happy to work on the study, by the way, as many of you know.
I think we should use Kickstarter to get the funds.
But my sense is that what you're going to find is people are going to be like, all the better. If I put it in the second case, he's not even going to know. He's going to know it's going to happen. He's not going to know why. It's going to be even worse for him. All the better.
Okay, so...
I mean, here again, I'm not a retributist at all, but I'm just like, if that's one of the reasons, it looks like that's actually going to be a reason to keep their incompetence in place, not a reason for getting rid of it.
Okay, so here's how I think a good retributivist would reply. And by the way, I'm not endorsing. I only ever report things these days, right? I barely ever endorse anything. But I try to passionately report them. So when somebody, if you've been imprisoned and you catch a cold or you catch some other disease, what ought we to do if we want to ensure that a person gets the just desserts? Should we just say, great, a bit more suffering, that'll be nice? No, actually, what we ought to do is to ensure that they don't just, experience this additional displeasure, because that wouldn't be part of their punishment. Or for that matter, suppose that, as it actually happens, prisoners get raped whilst in prison. Now, should we just say, oh, wonderful, they're getting even more punishment. That's exactly what we want. We want them to get more punishment. No, we want them to get the precise punishment that justice requires. And that wouldn't be part of the punishment. Now, in your particular case, the problem is that, yeah, indeed, look, the person might feel even more terror when they don't understand. But it's not the amount of terror, or even that the terror be of the same amount and the same kind, but that it's the terror that we intended to inflict, that that they need to feel. So that's partly what we're trying to do when we engage in retribution, or at least that's my understanding of it. So that's why, no, it's not the case that from a retributive perspective we should say, oh great, let's hang off, not restore competence, because hey, we'll get more terror. So, but here I'm simply reporting how I understand retribution, right? Again, I'm not endorsing this.
Let me take a shot at this as well, and I'll be foreshadowing a little bit about what I'm talking about later. But I think to the extent that retribution makes sense in here, it does have something to do with reconciling yourself with this is what I have done, this is now what I deserve. And you could go even a step further, and maybe now you're really on the bounds of agency here, and you want some regret. Well, the question then is, if the person literally has that agent regret and we know it, why are we killing them? They now know, geez, I did something incredibly wrong, and I will spend the rest of my life in prison for having done so. But if they've actually come back into some kind of moral agency, then why are we killing them? So that's where I leave it. I don't have an answer for that one either.
They should want to be killed in that case.
Yeah, I had one question, comment for Nicole, and one for Professor Morse. In the list of hypotheses that you were exploring, you just mentioned to perhaps, it's to allow people to make peace with their maker or with their life, depending on their ideological stance. But I'm thinking that I'm doing a lot of work on medical end-of-life practices and so on, and we are increasingly making people die, frequently against their wishes, in a completely sedated state. Continuous sedation at the end of life is increasingly becoming the most popular end-of-life decision, and even in Washington versus Glucksberg that you refer to, Justice O'Connor even said that the legalization of physician-assisted suicide is not necessary because continuous sedation at the end of life is a legal option. So we are increasingly, and we're not telling these people, oh, and you know what, make peace with your maker or with your life now, because in a few hours the midazolam or whatever is going to kick in. So that hypothesis seems to be completely in contradiction with the way more and more people are being made to die. And then I had one question for Professor Morse on the dignitarian approach. You quoted your colleague from University of Virginia as saying that this boils down to avoiding making people the object of the vengeance of the state. But I could see why that would be an argument for just not having the death penalty in the first place, but not an argument for restoring competence to stand trial, because you have already made them an object of the vengeance of the state by making them subject to this sentence, or am I wrong?
No, the question is whether people can never be used as a means or cannot be used only as a means. And all criminal punishment uses people in part as a means because of the pluralistic grounds for punishment that Nicole has talked about. I mean, if we punish you in part because it will deter other people, that is using you as a means. And the usual counter-argument to that sort of Kantian approach is to say we're not using you just as a means. And what Professor Bonney is objecting to is using you just as a means. And therefore he wants you to be able to exercise those autonomous choices at the end of your life, obviously restricted if you're on death row, but those autonomous choices that are still left to you as a dignified autonomous agent.
Okay, so in response to your question, again, putting on my reporting hat, wow, I feel like such a pretender here, I'm the pretending retributivist. Or maybe I'll talk myself into being one. So suppose that should we, for instance, allow people to say, oh God, you're going to send me to prison. Look, just put me on Valium. I don't want to experience any of this stuff. I want to be blissfully unaware of this. Or would that frustrate the aims of retribution? I think that if I were with my retributive hat on, I think that would really frustrate the aims of retribution. And to the extent that we currently allow people to do certain things like what you described, yeah, that's intention. So the retributives should stand up and say, hey guys, why the hell are you allowing us to do this? However, the answer might be because we have plural aims for punishment.
I think your end of life is distinguishable as a case because in those particular situations where the person is going to face enormous anxiety with breathing difficulties and the like, typically there is an advance directive for things like this, at least in the United States. Typically there are ethics committees in the hospital that have done this. This was a wonderful study by a guy at the University of California, San Diego, that looked at whether families and the like were satisfied. There is a substitution of judgment because usually those protocols aren't applied till the person is already unrestorably incompetent. Not always, but mostly. So I think this case is somewhat distinguishable. And I would hope, however, where these protocols are being used, where the person is still competent, that in fact then the person consents to the protocol.
But Belgium, Netherlands, etc. No, it's completely the opposite.
It's the opposite because in the United States, where if the person is competent, they have a right to say, you may withdraw from me all the following treatments, and I just wish to be made comfortable, which is what essentially living wills or advance directives say.
No.
Okay, we've got 10 minutes left in the session, the number of hands up, so we'll ask for quick responses. We'll get a lot of them quick.
All right, just to get this out of the way, death penalty, barbaric, horrible. I want to press back against the characterization, though, that the reason is somehow extrajudicial or aesthetic. I mean, the classical defense of the death penalty is from Immanuel Kant, right? It's respect for rational autonomy. It's taking autonomous agency seriously. So, I mean, it's also, rational autonomy is the characterization or the characteristic in virtue of which we actually count people as members and elements of a judicial system, right? So, the reason why it's important, I want to say, isn't because, you know, they'll make peace with their maker or something else. It's just because that's just a necessary condition for the possibility of there being justice enacted in these cases.
Again, I'm going to foreshadow some of the things I'm going to talk about this afternoon. And you're absolutely right in this philosophy of law. It's just to be honest, you get what you've given, you die, with a few exceptions, one of which is really infamous. But he wrote a book I didn't know about until about a month ago in the late 18th century called Anthropology from a Pragmatic Perspective, in which he says the insane, the judiciary shouldn't have anything to do with the insane because it's outside their camp. They shouldn't even be dealing with the insane. So insanity is something that Kant himself drew a little circle around and says, this is not part of my philosophy of law. In fact, it's not even legal. It's extrajudicial itself.
Francis, can I just come back to that point? So about the end-of-life situations and allowing people to sedate them, to be sedated. Note that actually, in a strange way, this connects very well with Thomas Nadelhofer's question and my reply to his question. In those are the precise occasions on which a person would end up having more suffering of the sort that we didn't intend them to have, right? So when we put a person in prison, it's not that we intend them to then undergo the suffering as a consequence of, well, all the deterioration that may happen at the end of the life. And so the reason why we might say is, look, actually it's fine to medicate them is precisely to ensure that those consequences don't inflict themselves on them, because that wouldn't be part of a just system. That'd be an injustice. It's, you know, it's a horrible thing. And also perhaps there's an element of mercy at work here as well. You know, so I just wanted to add those two things.
Not every person is competent.
Right.
Okay, all right.
And that's one of the reasons why, for example, one of the previous popes in an encyclical letter has said that sedation is wrong because it prevents people from maintaining consciousness when they die.
Nicole, if we could intervene in the brain of a demented person who committed a criminal offense so that they would recall the memory and be competent to stand trial, forget about the death penalty, just competent to stand trial. Is there
I'm sorry, to stand trial or to continue with their incarceration?
Okay, so to continue with incarceration. Okay. Is there a significant legal difference between forcible intervention in that case and forcible intervention in the case of a psychotic individual? So is there a difference, legal difference between a neurological disorder and assuming that dementia is irreversible for some sort of temporary restoration of competence and a psychiatric disorder such as schizophrenia, positive symptoms of schizophrenia? And specifically with respect to the liberty interest, do both of those individuals have the same liberty interest? Does the nature of the disease have anything to do with the liberty interest, or are they practically the same?
Can you just state the two different conditions? I didn't quite...
Okay, dementia?
Yep,
okay,
dementia.
because you mentioned this.
Yep, and the other one is?
Schizophrenia, positive symptoms, delusional.
And do I think that there's a difference in regards to whether it's fine for us to force treatment to make a person competent?
Yeah, the legal justification of forcible intervention.
I mean, sorry, I wouldn't see why. Can you tell me why there would be?
No, I just want to know.
So, I mean, my main reason for saying that I can't see why there would be a difference is because in both cases, what we would be saying is, look, we want to make sure that the just punishment is inflicted on this person. Right now it can't, either because of dementia or because of schizophrenia. To the extent that we can treat this particular disorder, we should treat this disorder. If we can't treat it, well, no question.
Okay, good. So the type of medical condition involved is not really critical. In these
That's right. I don't.
Okay.
Not to me. So for instance, suppose that if it weren't a matter of it being a medical condition, but rather I just became really stupid for whatever reason, right? Really, really, really dumb.
I get that.
And yeah, right. So do I sometimes actually. Now, would it be fine to restore my competence on those occasions? Even if it weren't a medical condition, it's just what I'm like, right? You know, I go dumb, I go really silly sometimes. Yeah, I think so. And the mere fact that I don't call it a medical condition, its medicalness doesn't seem to be here or there.
As a matter of positive law, I think, at least Judge Davis and I agree about this, that there doesn't seem to be a difference. And Nicole is just taking up what I talked about in my talk, which is that these things are really functional. It doesn't have to be related to a medical or a psychiatric condition. It most often is, but in theory, it shouldn't have to.
Right. And I actually tried to find an answer to that question, exactly that question this summer, and really couldn't find it. But one thing, kind of by analogy, there are lots of cases in which prisoners, as they age, wind up with end-stage kidney disease or some kind of end-stage liver disease. They go to hospitals, but they're in locked-up hospitals. So their sentence never ends, and I suspect that's the same thing that would happen with the dementia, although I was not able to find any answers to that.
Again, it is worth noting that we seem to make some difference in the civil jurisdiction, so mentally ill people can be detained without anything to do with their capacity, whereas medically ill people, it's all about capacity. So, I think that probably shouldn't be there, and that is disappearing, but that is an area of the law where there is a distinct difference.
One last question, and then response, and then final.
So we've been talking a lot about the kind of personal point of view of those who've been executed, but I was wondering if y'all could talk a little bit about how we restore competence to make society feel justified for punishment and how we can view them as like less mentally incapable victims per se, if that question makes sense.
I didn't quite understand. Can you say it more?
Well, like the reason that we restore competence, and like whether I agree or disagree with this, y'all touch upon it, for society to feel justified in punishing them because they won't be viewed as victims that are mentally incapable of making decisions and viewed more as the criminals of the actions that they've done.
What's the question?
Okay. Just like to kind of talk about that a little bit, the question of like, do you think that maybe we do that for society to feel justified?
So let me see if I get the idea right. So is the idea that, look, could we perhaps treat society's desire to have retribution? Is that the idea?
Yeah.
Feel justified?
Yeah, like justified in punishing. Like we feel justified in punishing, and that's why we restore the competence.
But see, your question, if I may, frankly, is profoundly acontextual because punishment, if we're talking about the United States, we're talking about politics. We're talking about politics. We're talking about legislatures that have created, for example, mandatory minimum sentences that deprive judges of discretion to achieve justice in the individual case so that politicians can go out and get elected to office on a platform of I'm tough on crime, I believe in throwing away the key. And going back to some of the earlier comments, America is largely alone in the world in these incredible lengthy sentences, even for murder. In Russia, you may get a 30-year sentence eligible for parole. In lots of other places. It's only in America that we have these life without paroles. I mean, the Supreme Court just a couple of years ago said you can't give a juvenile life without parole. So we are way behind the curve in these areas. And so I guess, again, my answer is let's not lose sight of, as important as this, our consideration of neuroethics is, and the moral imperative of this conversation. I mean, there's a disconnect between those of us in this room and the people with the power to drive the criminal justice system. And that's why I alluded to it as a terribly broken system, which is not to take away from your question.
It's a first world problem. That's a first world problem.
It's 12:05, so let's say thank you, and the discussion continues on the panel.
And thank you, Francis and Ted, for chairing this